just to briefly introduce myself while we try and get some slides going. So I'm a games lawyer working at media and tech firm Sheridans in London, and I work with basically developers and publishers of all sizes, both national and international, basically on all of the legal matters that surround creating and publishing of games. And that work means that I focus principally on IP, on intellectual property, because that is what is at the heart of all games law. I also do a lot of work on AI. I also do a lot of work on AI, and particularly where that intersects with creative industries, because obviously working in a very tech-forward creative industry like games, that understandable. I've been working with AI for some time, much longer than the whole generative AI boom brought it very much into the public attention. There's obviously a huge amount to cover with this topic, and as a lawyer, it is both interesting and a nightmare because the law keeps changing on a daily basis. I went away for a couple of weeks recently, came back, and there were like 3 new cases changing the law around it. So what I want to try and do today, what I thought might be helpful, is to firstly just start by introducing a little bit where the key fault lines are, where the key risks arise, and then give a bit of an understanding as to why this is so much in the public discourse, why it's actually, you've got 2 sides that seem to be fighting each other, but it's not as straightforward as perhaps the media might portray it. And then basically look at what you can be doing as developers to protect yourselves, but also if you are using this technology, how best to do that in a safe way. Because one of the strengths of the games industry and people who create games is the ability to harness technology and use it for incredibly creative, inventive ends. Now, that's very difficult to do if you don't actually understand what the parameters are, what the guardrails are, because you don't really feel certain that you can play around in that area if you don't know what's allowed. So hopefully this will help you with that one way or another. Now, thank you. You can see we've got my very sophisticated diagram of what a generative AI model looks at. And the idea, a lot of this, what I'm talking about is generative AI, because that is that's where all the contention is coming from at the moment. That's where all the risks arise, and that's where we're seeing changes in law on the horizon already being affected. So when I'm talking about AI, we're really talking about generative AI. So I suppose the question is, why has there been this plethora of legal controversies around Gen AI? There's over 40 cases ongoing at the moment. Some of them recently there have been judgments. So more keep coming in around copyright and AI. And as I'm sure a lot of you are aware, it comes down to the data sets. So this, the line on the pink line far left, but these will often include original creative works that were created by humans. We can probably actually, if we go next slide, you can see, there we go. We've got a very sophisticated, even more sophisticated diagram of how it works. They're comprised of original creative works made by humans. And if we're talking, image generation is often, it can be of human, or, cats in this case. And these original works are protected in some form or other by IP rights or related rights, such as image rights, which is where most of these issues will arise. So if we go to the next slide, what I've done here is a super sophisticated diagram of all of the different trademarks and copyrights and various rights that might be at issue here. So we've got copyright is obviously the one that is very much talked about a lot at the moment, and that is it covers a wide range of original creative works. It vests in literary works, it vests in text, dialogue, art, code, music, you name it. It does not, though, importantly, extend to ideas. So a creation will have to be written down. It has to drawn or recorded in some tangible form in order for it to be protected under copyright. And in the UK, there's no need for any additional registration or additional formality. It exists as a matter of law. Now, some of this will be familiar for those of you who attended the previous session on introduction to IP, but worth reiterating. It's an important one to talk about. It won't protect anything generic, and this is important. We'll come on to this later. It's only for original works, your own. Trademarks, so this is basically anything that exists in words, in logos. It's basically like a badge of origin, a stamp, that's sort of like a marker that shows what company certain goods or services or whatever come from, like, Nintendo, the word Nintendo, the logo Nintendo. They tell you, oh, this is something that was created by Nintendo. So that's trademarks. Design rights, slightly more niche type of IP, but again, worth mentioning because it's used to protect things that have a unique shape, a particular pattern, sort of layout, plan. So, buildings will often have design rights, cars, weapons. So there will be design rights. And then, again, so whistle stop tour. Image rights, particularly important in the age of Gen AI, and often talked about, particularly when we're looking at deepfake technology or double digital. There is actually no such thing as an image right under English law. It's more just basically a bundle of different rights of action that someone can use to try and protect their recognizable image or attributes like their voice. There's misuse of private information or personal data or passing off, which is where you're misrepresenting that your work is endorsed by someone, confidentiality. So it's not strictly an IP right, but very, very relevant to the discussion of rights generally that would be protected and potentially at issue when we're talking about Gen AI. So this is what will comprise, this is what will make up a data set. The issue is if you are training a model on a data set that is made up of all of these, is there copyright infringement? Is there trademark infringement? And the rights holders whose works are being used to train data sets will say yes, and this is what all of these cases have been brought for. Obviously, the tech companies, the AI, they're going to say no, there's not infringement. It's actually, in the US they call it fair use, whatever. It's actually this question. This is a key question that is not necessarily as straightforward as it may seem. There may be infringement in some cases, but actually in others it may be fair use. It may be you're not really using it to copy. You're using it to train and transform it into something completely different. So the question of whether having all of these rights in a data set is automatically infringing, it's not as straightforward as that, and that is integral to a lot of the issues at play here. Because if you're coming in as the end user, right? So you're using this technology. So where does that then lead you? If you know that there might potentially be some issues at the training stage, but you're just the one going in, putting in prompts and then creating something. What does that mean? So we're looking now at the outputs. So the next slide will sort of take you onto that. Looking at the cat. Now, this doesn't mean, knowing what we know about data sets, it doesn't mean that you're going in, you're automatically infringing. But what it does mean is you need to tread a little bit carefully. So if when you're inputting your prompts into if you're using this kind of technology, first thing you need to think about is you could quite easily, if you really tried, you could create an output that is actually infringing of the original work that it was created on. So an example that I like to use is there's a big difference between inputting, say it's image generation. You want it to create an image of a cat in a car. Pretty generic, very unlikely, highly unlikely that's going to come out with anything infringing, but you never know. Compare that to then inputting a prompt of a picture of Garfield driving a BMW. Now, you're obviously then going to be spitting out something that has copyright protected, trademark protected, design right protected works, and then throw in the, I don't know, add the face of Drake on top of Garfield. You've got image rights, you've got it all there. So how you use it will be determinative as to how much risk there is involved. So as a general rule, if you are using this technology, we can keep on the previous slide. Actually, no, let's move on to risks. So yeah, that and then to be honest, that's probably falling into the first one there. That's the sort of the infringement risk. You want to keep generic. You want to keep it non-specific. With that as well, thinking about hallucinations and biases, that's also when we're looking at the output, that's a potential risk as well. But we'll come on to that in a second. I might jump around this a little bit because thinking about inputs and prompts, confidentiality is key here as well, because I think something that perhaps a lot of people don't necessarily realize is that anything you input in this platform, even if you're in a stealth tier, that is not confidential. That is going to the platform owners will be able to access everything that you have included in your prompts. And I see it often, particularly on the agency side of things, when someone is creating a pitch, for example, they might put in the entire swathes of confidential information to help them create a tailored pitch, for example, for a piece of work that is most definitely confidential and should not be used in some kind of public platform. So if you do, if you are using this technology, as it's got to the stage where most people are, you just want to make sure that it is ring fenced. You've got a sandbox version, because in that case, you can, provided you're quite careful with the terms when you first get it set up, you can have it so that you can input confidential information, and that's fine. But particularly with the public platforms, they see everything you put in. It might involve also personal data. You don't want to be getting into data privacy issues as well. And they also have a very, very broad license to use anything that you input and anything that is spat back out. So this takes us onto the ownership point that we've got here. And this is, again, one of the big risks, I would say. Because for one thing, it can vary from platform to platform, depending on what their terms are. So firstly, you want to check what the platform terms say. And in almost all cases, what you will see is they'll say, you own everything you create. That's all yours. Your prompts are all yours. Then you'll see they have a license back. And this will be, as I say, a broad license to use the works however they want to, use whatever is output, use whatever is inputted, use it to retrain their model, use it for their own development purposes. So you own it, but kind of so do they. So you have that in mind as well. Unless you have your own, there's a ring fence sandbox tool. If you're using anything public, it's as if you're posting it in a public forum and giving people right to do whatever they want with it. So something to just bear in mind going forward. Another point on ownership, and this is more a bigger question that straddles all different jurisdictions from US, UK, EU, China, Singapore. Every jurisdiction has its own position on whether you can even actually own the copyright in an AI-generated work. Because if we go back to what we thought about, what we were looking at with that rights holder inventory, copyright vests in original creative works. And in some jurisdictions, China, Singapore, they say, it's fine. You can own any AI-generated work. It doesn't matter if it's a human or computer, that's fine. In the US, and actually with some in the UK as well, the position is more, you can't own an AI-generated work unless there has been that human original creative input. In the US, it's even more stark. It's like you can't own technically you can't own any of the AI generated parts. You can only own it to the extent that a human's edited it. In the UK, it's similar, but the position is more yeah, there can be copyright in, they call it computer generated works, but there still has to be, it still has to pass a sort of threshold of originality. It has to be sufficiently original. So again, you still need that human kind of original thought process. So it kind of comes to the same thing. So this is significant in that even if you have some sort of ring-fence sandboxed tool, so the confidentiality, whatever, isn't an issue, and the terms are quite clear, and they don't have a license back to use any of your work, there is still a bigger question at law as to whether you can even own what you've created. And what you'll find anytime if you're getting any kind of investments, or if you're going to insurers, they will, any investor, any insurer, they will want to get some kind of warranty. They will want to know that you own whatever you have created, and that you're kind of taking measures to make sure that you have that ownership. You don't tend to get so much straight warranties against, people saying, oh, you can't use any AI. It's more, okay, we're assuming you're using AI tools, but we need you to be able to confirm that you still own everything that you're creating, which basically means they recognize that this is a risk, and they want to make sure that you're mitigating that. And we'll get on to steps you can take to mitigate these risks later on. So ownership is a big point. And I think people are talking so much about the inputs, they're talking so much about the data sets, and actually there isn't as much discussion about the outputs. And I think that is actually where the next battlefields will be, essentially, will be on the output and questions around ownership. As it becomes more and more commonplace and people use it more and more, it's more just the market deciding for itself how it feels comfortable with these sorts of outputs, because the law is taking a long time to change and adapt. Compliance and transparency. When I put this sort of ties in a bit to the point around what investors and insurers are looking for. Because as I say, the market will decide how it's going to work this thing out, work this whole AI thing out. And that comes from, the money. So what investors are asking for. And as I say, they want to know that you are aware of the risks. They want to know that you are doing what you can to mitigate those risks. And so having some kind of robust tracking system of the tools that you're using, particularly for, if you are using AI as part of your development process, generally particularly, but, any kind of AI tool where it is a significant part of the output of your game, like what's going to be included in the final game that's going out to end users. Keep a track of that, keep a tab. If you're using a public platform, check when the terms, what version of the terms applied, what version of the product applied that you were using at the time, and have some way of tracking, your own, the human element, essentially, that, where that human hand comes in, so that if down the line you're getting investment and you want to we'll just finish up on the last slide very quickly. And you want to have, you want to be able to show an investor, look, we know what we're doing. Then you'd be able to show them, we've got an AI policy, we've got a tracker, and the AI policy kind of sets out, what the risks are and how mitigating the tracker tracks all of that. This is becoming increasingly commonplace now, and I'm rolling out an inordinate amount of AI policies at the moment for basically across the creative industry. There's a lot of games developers and should we say games adjacent companies and markets. It's an AI policy is quickly becoming, it's like when GDPR became a thing and suddenly there was a rush to get these policies in place. It's the same thing now for AI. So if you don't, something that you should definitely start thinking about, particularly if you're coming up and you want to make your company as attractive as possible for future investment. Start keeping a tab of this now, start thinking about getting some kind of policy. No, it's good, it's keeping me on my toes. Okay, that's like chaos. Not chaos at all, it's great, thank you for helping. Platform T's and C's, I've kind of already touched on that, but just a reminder, there will be stuff buried in those T's and C's that you will want to check for, particularly if you're relying quite heavily on AI. And then, the one thing I touched on briefly before, hallucinations and biases. This is a bit of a broader point around clearing your works, because, as I said, what is spat out, what the output is, there is still a risk that there might be something infringing, given what we know about the data that was used to train it, and that it might hallucinate. There might be biases. We know that there is an issue with biases in generative AI products. You type in "generate me a picture of a lawyer" and you get an old white dude, which so you've got to be conscious of biases that come out of this and the strange sort of hallucinations. And so my advice is always, you clear it like you would any other creative work. You still make sure that you're very careful to check what is coming out. So a lot to absorb there. Let's move on to the next slide, because I want to run through a bit of a summary checklist, as it were, of, look, these are things to think about if you are using it. And this is the way this is the way you can basically best protect yourself, because there is a final point that I'm going to finish on also around, as a rights holder, things you might want to think about to protect your own works online when it comes to AI training. But just to spin through, as I say, data sets, this is where so much of the contention at the moment lies. So if you do know what type of data set, if you're thinking of using a platform or program, you might want, check what data set is used. Sometimes they're not very open about it. That may change in the future with regulation, further legislation. They may be required to reveal what data is trained, but believe me, the AI platforms are going to resist this as much as they possibly can. And in many cases, people don't actually necessarily know what is contained in the data set. So if you don't know what data is used to train a model, what this LLM is made up of, it's fair to assume that it's not all cleared. So just have that risk element in mind as you move forward. Check the T's and C's. So that's the next point, next slide. And that is, as I was saying, just checking for the ownership, checking on the licensing point, what kind of license back do they have. Check what the position is with respect to their liability, for example. It's in many cases actually they will just exclude all liability and kind of put it on you. But you want to be sure that you're checking the T's and C's, even if you're using it, as I say, on a sort of ring-fenced, sandboxed basis. You want to be particularly careful that you are certain that your data is confidential, like what you're inputting, what you're getting out is confidential. It's not being shared back with the developer, because you don't want to find yourself in breach of an NDA, for example, if you're doing work for you're doing co-dev work, for example, and also personal data, making sure there's no personal data slipping in there. Can we skip ahead a couple of slides just for example completionists, so you can move down the list? Isn't that fascinating? Generic and non-specific, as I said. So when I say that, I mean when we talk about prompts, think of the cat in a car versus Garfield in a BMW example. Making sure that AI is great for, like grunt work, for doing stuff that is really time consuming, that you don't necessarily have the resources to do, that is more just kind of basically helping you get through huge, whether it's on coding basis or kind of doing original ideation and sort of conceptualized stuff, that you're then going to come in and have that human element, that human kind of original thoughts, and then take it further. So try and keep it to that. And this is not to say that you shouldn't experiment and use it as you can, because I do also think there is a huge opportunity in many respects for indies in particular to start coming out with far more polished products and games than you would have been able to do, back in the day. And what with the difficulties we're seeing in the industry and the market, it could actually be a really useful opportunity to play around with ways of being very creative. And some of when I feel a bit more optimistic and positive about this kind of technology is when I see truly creative stuff from small, 1-2 people teams who have kind of found ways of using AI in truly creative ways that you just wouldn't have been able to see before, and they were able to sort of create ideas that they didn't have before. So when I say generic and non-specific, I'm not saying don't play around with it and try and be creative. It's more specifically with the prompts, right? And then human and original, the next point, that is ties in with the same point. You want to avoid any purely raw output being, from a third-party AI tool being used in any external final product, final game. You want to edit it. Remember the point in the US that you don't own any AI-generated works unless it's been edited, and only to the extent it's been edited by a human. So just kind of have that in mind, that you still need to have human creativity throughout the process. And finally, clearance. As I say, I'm probably going to sound like a stuck record. Like you want to make sure that you are treating it like any other work that has been created. You want to go through and, using image generation because it's an easy example, but it applies to anything, like checking for any logos that slipped in that maybe shouldn't be there. Checking, see if that cat looks a little bit too much like Garfield, like that car looks a little bit too familiar, because the big IP holders, they have their own vested interest in making sure that people aren't using these tools for obvious reasons to infringe, but also because in many cases the large IP holders are creating their own LLMs on the basis of their own vast back catalogs of assets and materials. So that's a whistle-stop tour of things to think about when you're using these tools. I mean, for some kind of, I would say, bonus points, some things we want to think about are, of course, having in place a policy, an AI policy. And as I say, this is increasingly becoming a necessity. It's a given that you should have one at this stage. So definitely think about getting a policy in place, getting a tracker in place so that you're already starting to track what kind of AI technology, generative AI technology particularly, is being used. And as a further bonus point, I would say also thinking about it from the flip side. So you have created some amazing works, creative, original, very much your own, whether AI assisted or otherwise. Like you have your own IP that you're building up, and the value of that is, that is the whole value of the games industry in many respects, is the various ways that companies have created new IP. So you want to also do what you can to protect that. And what is interesting, I don't know how much people saw of the whole kind of government consultation recently around copyright and AI, and whether they should be changing the laws around copyright, and whether there should be an opt-out model, which is essentially to say that unless you opt out of your works being used for data, AI training purposes as part of data sets, then it will be automatically used. A lot of issues with that. We actually showed, we do a lot of this, and I fed back on the consultation with them, work around this and close to this, basically highlighting that there are issues with this, various issues, not least just purely technically, how on earth do you opt out in both a human readable way and also a machine readable way. It looks like there is some sort of technology coming down the line that maybe would be workable, sort of a combination of fingerprinting and watermarking and CTPA, but that's not there yet. And I do think that it looks like we're not, the government is possibly going to be rolling back on this idea of an opt-out. But in the meantime, what you can be doing is still opting out effectively, but just doing it in your teams, the T's and C's on your website. So anywhere you're putting your own works up, if you're an artist, if you've got your game up anywhere publicly as part of just the general customer facing, public facing terms and conditions, have something to say, we do not authorize use of these works for AI training purposes. Now, that's not to say it won't be scraped and used for AI training purposes, but if you find out that it is, it means that at least there is some basis, like you have a contractual recourse against anyone who has used your works for AI training purposes. So there are still, you still want to think about whether you want to protect your own works, and there are things that you can do. A small update to your terms and conditions can help. For the time being, there has been no change in the law here in the UK around using copyright and using protected works for training purposes. So you don't, we're not at the stage yet where you have to opt out. But in the meantime, just do all you can to be preempting that and also preventing people from using your works without your permission. Because fair to say, I think we know that everything that's on the internet has already been scraped. It's more a matter of protecting yourself going forward. But anyway, hopefully this helps give, as I say, whistle-stop tour, but an overview of the understanding of the issues, of the risks in using this technology and how to then mitigate it, some practical steps in how to use this technology safely, and also how to protect your own works when you're putting them out publicly. I mean, this is, as I say, this is a very much shifting legal landscape. That doesn't mean that to say you can't play around and leverage this technology for creative ends. It's just a question of basically using it in as future-proofed a way as possible. And these steps will help you do just that. You can basically pinpoint where the issues are and why, and then, as I say, kind of basically build your own way of leveraging this technology safely, ethically, and also creatively. So you can start taking creative risks, which is what is such a strength of the industry. Now, I've probably given you enough food for thought. I know we've got, I also want to give a fair bit of time for questions. Just as a sort of general caveat, if you have any questions that are, say, quite specific to your own plans or your own business, then I'm happy to, you can drop me a line afterwards and we can talk about it. But yeah, to be honest, I might open it up for any questions. I see that there might be some Q&As somewhere, if we can get it. I'm just going to jump in and sort of have a look at any questions in the Q&A, and feel free to sort of, if you want to ping in the chat or whatever, just jump in. So when you mentioned there needs to be some form of original creative thought process or editing or human creativity when it comes to owning all or part of an AI piece, what counts? Context below, okay. Artwork, graphic design, does it come down to manipulating? I mean, yeah. I mean, this is a very good question. Hang on, I'm just coming on to part two. So this is actually a great example to use, and Photoshop is often one that I often use as an example. And there's no definitive answer as to what counts as, enough. If it's like a tiny tweak of something that doesn't fundamentally change the overall image, then I wouldn't say that is enough. But you've also got to think of it in the round in terms of how much editing. If it's like, add a dragon to the sky, that isn't if that is, then that's it, that's done, and you spit it out, and that's the final work. Then what you've got is something that is largely just your kind of, should we say, creative input there has been minimal. But adding a dragon to the sky and then making, adjusting the coloring and making it sort of fit with the atmosphere and the background and sort of the larger piece, and then maybe adding on a few more layers and adjusting it more yourself, like that, that's a creative process, right? And this is part of the issue as well. Like AI has been used, part of these tools, and for donkey's years. This is not, the concept of having AI assisted creation is not new. It's generative AI and being able to create, should we say, sophisticated creative outputs with very minimal human oversight. So yeah, a human could prompt Photoshop, as you say, and add a dragon to the sky. And then it's a question of the level of engagement, level of editing and involvement that human has. It's a bit of how long is a piece of string, but I think it's a question for, if you are the one using this technology, you're the one kind of creating the images, you're basically, that's part of the tracking. You want to be able to show, yeah, I might have used AI to create a dragon, but this is all the steps I did after it. And even if it's AI do some editing, AI, you're doing all of that layering. I'm sure at each layer there's AI generation. You compiling all of that and thinking how you want it all fit together, that's a creative process. That would be how I would argue it if I were coming on this. But yeah, it's a very good question. Coming in with Keith's question as a voice actor, I mean, yeah, don't know, it's some use of, yeah. So I'm glad that you brought this up, and I do work with some, voice actors in the space as well. And this, the question around sort of legal protections for your own work in terms of this is where you get into image rights, personality rights. Sorry, I've just seen that there is a follow-up. Are there any other international companies use it? Yeah. So just to step back a bit when we're talking about anything that involves the identification of the other person, image rights, so your face, just personality rights, your voice, mannerisms, this kind of thing. So this brings in mocap as well. I would say the US is actually been leading the charge on this and doing much more in this than say the UK, which doesn't, as I say, doesn't even have an image right. My view is we're spending a lot of time talking about copyright, and the government spending a lot of time talking about copyright and things. Where we really do need a change in law is image rights. My view is, and this is my view, I think we do need to have some kind of image rights in the UK when we're looking at this. We're looking out, and there is sophisticated deepfake technology or double digital technology being rolled out. Now, in some cases, it's being used in quite positive ways, with the consent of the person that is, they are trying to recreate. But in other cases, we obviously know less so. So as I say, in the US, there have been some cases on a state-by-state basis. So, there's, for example, the Elvis Act in Tennessee, which prevents use of a person's image even after they've died. They're really looking to legislate for this, and we're making some good progress until the head of the US Copyright Office was fired, which puts a bit of a blocker on things. But yeah, it is something that I think in the UK it would be extremely helpful for us to have in place. But in the meantime, what you're looking at is that there are ways of protecting or enforcing your rights, your image rights, your personality rights. In the UK, it just relies on various different angles, but we have had some success with this, and have been involved in some enforcement. So it's not without hope. There are things that you can do to prevent people from using your voice and your image. Going forward in terms of protecting yourself when you're launching a new piece of work, for example, I mean, it's contractual carve-outs. It's making sure in your agreement that it's very clear that if it's mocap or whatever it is you're doing, this cannot be used for AI training purposes without your consent, and making sure that you have as tight as you can. And similarly, it comes back to the point around, so contractual carve-outs one, and your T's and C's on your website, also just making it clear that you do not authorize any use of your image for AI training purposes anywhere that and the difficulty with this is if you can't necessarily track all of the places that your image is gone and your voice is gone. And that's part of the issue with the technological solution that we need to start looking at, and that may come up off the back of all of this AI discussion. But you can do what you can for now with, as I say, just updating your T's and C's. There are sort of domain-based protections you can also use to try and stop web crawlers. It's not foolproof, like, robot.txt. That again, they sort of work, but it's a page on a page-by-page basis rather than actually following the image, whatever the work itself, wherever it goes in the internet. But so there are some technological solutions you can use as well if you want to stop crawlers from accessing a particular website. So yeah, I would say contractual, just being very careful with your contract whenever you enter into a new contract, and they would expect to see this. I think anyone engaging an actor will expect to have to talk about the AI stuff. And if they do want to use for your image for AI purposes, you narrow the scope very specifically, and you negotiate hard on the fees at that point as well, because that's a very different kind of deal. Contractual carve-outs, T's and C's, technological solutions, and then also there's the enforcement after the fact as well. And there are rights of actions that you can pursue if someone has used your image or your voice without your consent. I hope that helps. That was quite a long answer. It's a big question and a good question, so thank you. George, in the case of the use of AI in games marketing, where does the responsibility lie when material generated AI? Yeah, I mean, again, these are some great questions here. Yeah, you're asking all the good questions here. So it's currently unregulated in the UK in terms of having to disclose that something is AI generated. It was looking like it may move that way with the EU AI Act, a vast and unwieldy piece of legislation that they're actually now kind of rowing back on that they were going to roll it out, and they're now pausing that because they basically realized all of the practical difficulties of enforcing AI technology with one piece of legislation that isn't really, as I say, it's a bit unwieldy. But one aspect of this that was going to come out next year, one obligation was going to be around disclosure and transparency of, for example, any AI-generated, particularly deepfake technology, deepfake materials. As it currently stands, there isn't a requirement to say, yeah, that this was generated by AI for your own purposes. You want to have keep a tab on what is and isn't. And this comes almost more down to sort of a reputational point. It's more of a PR point, because we know that in some cases, if you're trying to pass something off as something created by a human and it's going to be AI generated, that's more sort of thing, you get reputational backlash from that. But yeah, that's when the kind of the misleading element comes in. If you're saying, yeah, I created this myself by hand, and it was generated by AI, and you're trying to, use that to sell something that's to do with your creative act, that's when you start getting into, you're misleading what you're selling. But just, using something that was AI generated, maybe the tweaking here and there, that's not something where you have to put, and this was created by AI stamp. That's more just a question, like as I say, a bit more of a PR question as to how you want to approach that. I'm not sure. Have I picked up all the questions? If I haven't, please just drop another message. I think I've got them all, but if not, please just jump in. As I say, in some cases, if you have kind of a question that's a bit more specific to something that you're currently working on, and you don't want to talk about it here, that's totally fine. You can drop me an email afterwards. I think my email might have been at the end of that presentation. I can also drop it in the chat. But yeah, unless there's any other questions, yeah, I mean, go for it. Jump in.
Hi, I just realized that the recording of this is going to eventually end up on YouTube. So I stopped the presentation on your email because I wasn't sure how comfortable you'd be being permanently on YouTube. But in case anybody does have any further questions, Anna, if you're happy, I can start a thread in the Limit Break Discord. with the presentation slides and email. And then
Yeah, that's the I've just dropped my email in the chat as well, and I mean, well, actually, you have the slide. I can send you maybe just a sort of simple PDF version. So, but yeah, it was great to chat to you all. I'm always a huge fan of limit breaking and everything we do there. So it's always a pleasure to come in and talk and support how I can. And I could have talked till the cows come home about this kind of stuff, as you can probably tell. So yeah, oh, sorry, you were saying something.
We do have one last question that's coming from Key. Do you mind if I just read it out?
Yeah, read it out.
I think a lot of us fear the day we find our voice and our work AI'd somewhere without consent. How would individuals go about addressing this use?
Yeah, so use of your works and your image without your consent. I mean, yeah, that kind of goes also back to the question around it's the sort of the image rights and rights of action question. But yeah, if you are aware that someone has used your works without your consent, in some cases it's quite blatant. You can clearly see that they've, used your works or kind of recreated something that's, if it's a voice that sounds exactly like you, or an image that's clearly taken from something that you have done, then that makes the lawyer's job easier, because there is a slightly clearer right of action. And as I say, there are ways that you can go around this. There are rights of action in terms of passing off. So sort of there's been misrepresentation and that's resulted in damage. There's misuse of private information, misuse of personal data. I mean, personal data is quite a useful one. In some cases, it can be just straight up copyright infringement. That can be, it can be difficult because when we're talking about AI generated work, what you need is that smoking gun, essentially. You need that point where it's clear that they have copied your work, not just created something similar. But this is also why, if you have, some kind of evidence that's, pretty conclusive that someone has used your works without your consent, if you have something in your terms and conditions, for example, that says you can't do that, then they've also breached that contract, because any public-facing terms and conditions are effectively a contract between you and the person accessing that website or whatever. Which is why, in a games end user license agreement, you'll have all sorts of, restrictions on how people can use the game and what they can't use it for. That is a contractual relationship that you're creating there with the end user, and it's the same with anyone accessing your works. So while having something in your terms and conditions isn't necessarily, it's not going to stop a web crawler, it's not machine readable, it gives you that right of action. So it is worth having that, because what you want to do when something like this might happen is you want to have as many things to throw at them as you can. It's not just one thing, you want the whole gamut. So doing what you can to provide those protections beforehand, helpful. And even if you don't, there might still, there's still causes of action that we can look at. As I say, I do feel like this is an area where the law could do with a little bit of reform when it comes, particularly when we're looking at image rights. Yeah, I hope that helps. Feel free to drop me a line afterwards if you want to chat more about it, because it's a lot to cover with this kind of stuff. Cool.
Awesome. Thank you everybody for joining, and thank you everybody for also just chucking in your questions and keeping the conversation engaging. Thank you, Anna, again, and Sheridans for running this event. And yeah, I will close the recording here. Thank you.
Thank you very much, everyone.